Hi there, and welcome to Employment Hour in 30. Well, that's 3, but just add a 0 and you'll get 30. I'm John Scholes. He's Lior Samfiru. He's the pro. I sit here and try to make him look good. Seriously, though, we talk about lots of things over the next 30 minutes under the umbrella of employment law. It could be your severance. It could be a paid vacation. It could be workplace rights. It could be the boss you love, the boss you hate. We'll get to all that and some phone calls from our radio show. By the way, you can go to employmenthourtv.ca if you want to see where, or at least listen to our radio show, and find out a station near you where you can catch that. And contact anytime, 1-855-821-5900, and help at employmentlawyer.ca in the meantime. So, my brother, lots to get through today. What's going on?
A lot to get through, busy show, and always a pleasure to be back here and talking about employment law and workplace rights, and hopefully getting the opportunity, as we do every week, to educate and inform people. You know, the best thing for me, the most rewarding thing for me about doing this show is people contacting me after and saying, you know, I heard you on the show and I learned something new. It made me feel better about my workplace situation. I know what to do now if I'm facing with a problem, which is exactly why we're here. We're here to help people, to educate them. So if you don't know what your workplace rights are, and there's a lot of them, you have good rights, believe me, well, we're here to talk about that. And of course, if you have specific questions about your situation, we'll give you plenty of opportunity to contact me while we're off air here so we can talk and answer your specific questions. And we always like to start off with the situation that came across my desk just very recently, because I think there's important lessons to be learned. So let me tell you about a gentleman who had contacted me. He had worked for a company in a fairly senior position. He had some significant managerial responsibilities. He had a whole team that he was responsible for. He had done it for a long time, over 10 years. Well, recently the company decided to do a restructuring. I think they called it a realignment. And they said, we're going to keep your title. We're going to keep your compensation. We're going to put you in the same level on the organizational chart. Okay. But what we're going to do is we're going to take away your reports. You're not going to have anyone reporting to you anymore. They're going to be switched to someone else. So you're not going to be actually managing anyone, although you still have a title. I think you had a director's title. And that's what we're going to do. Now, the problem with that for him is that even though they don't change his title, his stature in the workplace is going to be decreased. People are going to know that now he's no longer a manager, he's no longer a boss. And the other problem with that is, let's say he moves to another job a year, 2 years, 10 years down the road, right. He's going to be able to say in his resume that he's not managing people, which means it's going to potentially hurt him finding another job. So he was upset about that, and he called me and he wanted to know, can they do that in light of the fact that they're not changing my job title, they're not changing my compensation? So here's the thing. If the company is doing something that reduces the prestige of your job, that reduces your job stature, that is something that they're not allowed to do. In other words, by doing that, they may actually be constructively dismissing you. So that is a constructive dismissal, which is a significant change to the terms of employment. So what I told them is, you can accept this. The problem with accepting this is, first of all, you've opened the door to potentially future changes. You've allowed them to make this change. Right. Down the road, they can make additional changes. But number two, even beyond that, yes, this is a big deal. I can see why you'd be upset. Objectively, that would be the case. So if you'd rather leave it with severance, that's something that you can do. Now, the other thing, the last point I'll make about this is, right now he's a manager. So if he gets severance as a manager because he manages people. Yep. If he's let go a year later, now he's not a manager. He has a fancy title, but he's not a manager. He gets less severance. Because remember, the type of job that you have has to do with, or impacts your severance. So there's many reasons why he shouldn't accept this change. And I want our viewers to understand that if your job changes, even if your title is the same, even if your compensation is the same, but the actual job changes, that could still be a constructive dismissal.
See, that was a smart thing for him to do, to contact you, because a lot of people in that case would just say, oh, I'm making the same money. I don't have as much to do. This is good. Let's go with it. Got to think ahead.
Think ahead about his career, right. About what that means to his future job here, about what it means to his stature, how he's going to interact with other employees. All those things you have to consider. And in this situation, no doubt in my mind, a constructive dismissal.
Again, contact 1-855-821-5900, help at employmentlawyer.ca. You want to go to employmenthourtv.ca, find out where you can listen to the radio show. We've been doing that for, I think it's 5.5 years now. We've been on the air on radio. Take a ton of phone calls every week. We'd like to play some back here on this show, get some feedback, get some color, some dimension to what those phone calls take place every week. So let's roll one.
A friend of ours is 60 years old, worked 32 years at the same company. It's a large company, making $45,000 a year. I'm not sure if it's run out, but she was given 8 months severance. I'm fearing that she signed.
That's like A third.
Yeah, that's a terrible situation. Wow. And it's a situation that we come across very often, which is why we wanted to bring this up here on the show. A situation where someone was offered a heck of a lot less than what they're owed and accepted it. So let's break this down. If she's worked there for all these years, age, position, and length of employment, right, are the factors that go in. So if she's 60 years old, 32 years of service, she'd easily be looking at 18 to 24 months of severance. So if she was offered 8 months of severance, that's a fraction of what she's owed. And the problem is if this person calling is correct and her friend signed the offer, she's stuck. Even though it's a lot less than what she's owed, even though she's feeling that she was taken for a ride or taken advantage of, you can't do anything about it once you sign that severance offer. So what do we do here? Well, in this situation, she may not be able to do anything, but for our viewers, for those that may find themselves in this situation, you got to get some advice if you lose your job, but you can do that even easier. SeverancePayCalculator.com. We'll talk about that more in a second. So let's take this information and plug that into the Severance Pay Calculator so that we can see what the result would have been. So I picked a position. Let's assume this person was in a clerical role, 32 years of service. You can see on the screen, 60 years old, salary of $45,000. She was offered 8 months. She should have gotten, as the severance calculator says, 18 to 24 months pay, and I did the math. That's somewhere between $40,000 to $60,000 difference. So she was owed an extra $40,000 to $60,000. I actually think she would have been closer to the 24 months than the 18 months, so about $60,000 less than what she's owed. That's why it's so important. So I had to break some bad news to this person and say, you signed this, even though you're owed another $60,000, not much you could do about it. But please, if you're watching right now, don't let that happen to you.
And it hurts big time because 60 years old, out of there at that age, $60,000 gap. I mean, that smacks of retirement income that she could have used.
Yeah, and it's the problem is at 60 years old, it's going to be more difficult to find another job than if you were 40 years old. So because of that, one of the many reasons why it's so important to get the severance that you're owed. What if you don't find another job? Right. What if this is the last job you have and you walked away from $60,000? A terrible, terrible situation. And as bad as it sounds, I see this every day.
Again, employmenthourtv.ca if you want to find out where you can listen to the radio show. A ton of phone calls just like that one. I want to let's get to another one. We'll play another one.
I'm wondering what happens with severance when a company terminates an employee that they believe is with cause, but it's contentious. It was a relative who had worked for the company for 11 years. They had terminated him with cause, they stated, due to absences and pretty much absence-related reasons. He had worked for 11 years. I had advised them to ask about severance, and they stated because it was with cause, severance isn't part of the entitlement.
Well, with cause is the big elephant in the room.
That's it. Yeah. It's a question of not really did he do something wrong. It's a question of whatever he did, does it rise to the level of cause? Now, if this person was absent from work, that's not a good thing, right? You should be at work, and unless you have an authorized absence, you shouldn't miss work. But the fact that he missed work does not mean it's cause, does not mean that he's deserving of the worst penalty. So is it cause? Well, again, if we're talking about a number of absences, depending how long they were, depending how frequent they were, it probably isn't cause. And if you're let go for cause when there really isn't cause, that's a wrongful dismissal. You're owed severance. Employers oftentimes, in my experience, try to avoid paying the severance by saying they have cause and by jumping the gun when whatever it is that the employee did is not bad enough, or the employer didn't dot its I's and cross its T's by having performance reviews, by having prior discipline, not properly documenting it. So as a general rule, John, and for this person that left us the call there, is if you're let go for cause, unless you did something pretty nasty, it's probably not cause. You probably are owed severance and full severance. You don't get a discount, or the company doesn't get a discount, just because the employee did something wrong. Again, wrongful dismissal.
Well, you've often said it's quote unquote the death penalty of the employment relationship. Plus, wouldn't they've had to have a series of warnings and write-ups and to rise to cause, as you said?
Absolutely. Again, unless he's stealing from them, for the company to use performance or any misconduct really to establish cause, they'd have to show that they try to fix the problem. We try to warn him. We even suspended him. He's not getting it. What more can we do? You can't just jump through or bypass these steps. You can't jump over them. You have to follow the steps. And if the company doesn't do that, it's not cause, again, wrongful dismissal.
This sound familiar to you? You'll want to reach out, contact Lior, member of the team, 1-855-821-5900, help@employmentlawyer.ca. We talk about a lot of stuff on the show. We usually have a weekly topic when we do. This one deals dealing with a bad boss. I mentioned that kind of in my my opening statement. So I'm going to read some of these. You can expand on them because I know these are questions you get and we get all the time in the show as well. Number one, what are the most common bad bosses an employee may encounter?
Yeah, a bad boss.
Yeah.
We've all seen it, unfortunately. Not the people that work for me because I'm a great boss, but most other people, in fact, may encounter in the course of their employment a boss that's not wonderful. And obviously that's a problem because you work a lot of time with your boss. They tell you what to do, and if they're not doing a good job, if they're out to get you, it's going to cause problems. So we want to talk about how to deal with that. Well, a bad boss generally comes in one of two categories. Either someone that's not very good at their job, and in doing that, they make your job more difficult. They make it more difficult for you to accomplish what you need to do, and then you're afraid that you're not doing a good job, and round we go.
Right.
That's the number one. And I'd call that the innocent bad boss. And there's the non-innocent bad boss, which is the boss that's out to get you. Maybe there's a personality conflict and they decided they want to get rid of you. Maybe they think that they want to hire someone else. And because of that, they take it upon themselves to make your life miserable, make your life difficult, to have a poison work environment.
Right.
So those are the bad bosses. Both of them are bad, and what we want to talk about is how do we fix that, how do we deal with that, and hopefully rectify the situation.
Well, that's kind of the next question. Like, at what point do you know you have a bad boss and you have to do something about it?
If you're hating going to work, if you're dreading going to work, if you're going to work and are worried about what your boss is going to say and do, you have a bad boss. You have a right to be in a supportive work environment. You have a right to be in a positive work environment. And frankly, it's up to the boss, the person you report to foster that environment. So if your boss, the owner of the company, whoever it is over you in the totem pole, fosters this negative poison work environment, you have a problem, and that's when you got to act.
So now you've realized you've got a boss that fits the mold of being a bad boss. What do you do?
Well, the first thing I would always try to do is see if we can deal with this internally. Let's find out what the reason is. Is it something that you did, and then you can talk to the boss about it, how to fix that? Is a personality conflict that you can address with the boss? Is it something you can go over the boss's head and talk to someone, an HR person, the owner of the company? Try to deal with it internally as best as possible. Give it an opportunity. Give the company an opportunity to fix the problem, if at all possible. And if you do that, I always want it to be in writing.
Right.
Okay, if it's not in writing, it doesn't exist. It's okay to outline your concerns. It's okay to outline your problems and even to outline your expectations. As long as you do that in a respectful way, it's fine. You don't have to be shy. You don't have to avoid that. So don't be afraid to do that. Outline what you're afraid of or what's been happening, and try to give the company the opportunity to fix that problem.
We'll call that step one with dealing with the boss directly, possibly HR. Okay, doesn't work. Now what's my next step?
Well, the next step would be, again, document, but we may then have to deal with it externally. At that point, we may have to say, we've tried to fix this. The boss is not correcting his or her behavior. It's still a poison work environment. We need to do something about it. If you don't do something about it, you may find the situation getting worse. You may be losing your job. You may potentially find yourself going on a medical leave of absence because of stress. So at that point, we may need to deal with it externally. The way we would do that is we may be able to treat that as a constructive dismissal. A bad boss creating a poison work environment often would result in a constructive dismissal. We may be able to send a letter to the company from me telling them, you got to deal with this. Rather than ignore this bad boss situation, you got to fix the problem. So we'll try to fix it that way. And if not, we'd have to pursue this as a constructive dismissal.
If you don't realize that, or if you don't go on a medical leave, but day after day it keeps getting worse, it's like, man, you were about to blow your stack. Those two words are about to come out of your mouth. I quit. I've done it. Should you do that? Can you do that?
I would not do that without setting the stage first. So rather than just resign kind of in the heat of the moment, it's okay to resign, I guess, if you set the stage in advance. You've tried to give the company the opportunity to fix the problem, and they haven't. And then you say, I've tried to do it. I've tried to talk to you. I've tried to talk to the boss. Nothing's happening. Things are getting worse. I can't take it anymore, so I'm leaving. So if you're going to leave, you have to do it smartly. You have to say in writing why you're leaving. You're not leaving because you want to spend more time with the family. Yep. You're leaving because of this bad boss. Now, as a proper word of advice, I don't want anyone to quit, bad boss or not, without speaking to me first. Because I want to help you in making sure that if you do quit, that you don't just quit without compensation, that we can set the stage to be able to get you compensation. Because if you quit because of a bad boss, frankly, it's not your fault. If you've tried to fix the situation and it didn't get fixed, again, it's not your fault. So if you do leave, you should be getting compensation.
You need to reach out, by the way, 1-855-821-5900, help@employmentlawyer.ca. Finally, Other side of the chair now. You're the bad boss. Someone's complained about you. It hasn't been fixed. What do you do as the boss?
Yeah, well, obviously, what you don't do, let's start with that. What you don't do as a boss is you don't take it out on the employee. You don't say, someone complained about me, I'm going to really show them and make their life miserable. Terrible idea, because if you do that, you may find yourself potentially in a human rights situation. You may find yourself with your boss getting upset at you. So I would try to resolve the problem. If you did something wrong, fess up to it, okay? Admit it, try to work out the issues. If you disagree, if you think that this employee has it in for you and you don't think that you did anything wrong, well, then again, put that in writing, outline your position. But no matter what you do not take it on the employee. That's a recipe for you, the boss, being a subject of a lawsuit. Terrible idea.
1-855-821-5900, help at employmentlawyer.ca. We'll take a short break. Employment contracts will tell you why you got to beware of those sometimes. That and Severance Pay Calculator after we come back. Hang on.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact. Over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact. The labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first.
Hey, welcome back to Employment Hour in 30. If you're just joining us, I'm John Scholes. He's Lior Samfiru. We talk about your employment rights and a very special thing we like to talk about every show. This is huge. It is well over 500,000 uses now. We're talking about the best way to find out how much severance you are owed. It is practically bulletproof. SeverancePayCalculator.com.
I cannot understand why anyone would not use the Severance Pay Calculator, because it's so easy to use. It's so important information to have. So what is it? SeverancePayCalculator.com. Again, SeverancePayCalculator.com. A tool that I created in my efforts to try to inform and educate people about legal rights. So it tells you and it calculates for you how much you're actually owed if you lost your job. The real amount. It's not a week per year. It's not 2 weeks per year. It's a lot more than that. That's what the law provides. So once you go to SeverancePayCalculator.com, you'll be asked a few questions about your age, your position, and the length of your employment. And once you answer those, that's it. You're done. It's going to tell you whether you're owed 12-month severance, 24-month severance, or anything else. Anyone can use it. It's completely free. It's completely anonymous. You don't have to put in your name. You don't have to put in the company's name. You don't have to put in anything that identifies you, okay? And it's such important information to have, even if you haven't lost your job, but you want to be prepared for that day. If it comes, now you know. So go to SeverancePayCalculator.com, even if you're just curious, and you know, put a number in your head before you go there. Think about how much you think you're owed, and then use SeverancePayCalculator.com. I almost promise you that the amount, the real amount that you're owed, is a lot higher than what you think, because that's the way it is. That's what the law provides. So check it out now, SeverancePayCalculator.com.
You know, I want to read an example here in a minute, but it gets me thinking, why did you have to come up with this?
I came up with it because I was speaking every day with people that lost their job and contacted me when it was too late, because they didn't know any better when they lost their job and they were accepting a lot less. They signed off and I couldn't help them. So I wanted people to be able to get that information when they need it in the most accessible way possible. Some people don't like to call a lawyer. I get it, no problem, which is why you don't need to call me if you don't want to find out what you're owed. That's why I created the Severance Pay Calculator.
Or they'll call the labor board.
Oh gosh, that's the kiss of death, because unfortunately the labor board, the Ministry of Labor, the fact is, can only advise you with respect to your minimum entitlements, which is a small fraction of what you're actually owed. So if you're going to accept the severance package based on that advice, you're going to be walking away potentially from tens of thousands of dollars that you're legally owed.
So check it out while we go through this example again, SeverancePayCalculator.com. This example, my father owns a tractor trailer that has been operated by the same driver for the past 15 years, doing runs for different companies. My father wants to retire and get out of the business. Would he owe the 55-year-old driver any severance?
Yeah, well, it is what it is. Small business. So this small business, obviously, you know, maybe a kind of a family-owned business. And a lot of people think, well, small business don't have to pay severance, or at least not the same amount of severance. So let's be very clear. Big business, small business, the same amount of severance has to be paid. So to answer this question, let's actually use the Severance Pay Calculator. Let's plug the information into the SeverancePayCalculator.com website and see what that gives us. So A laborer here is going to be terminated with 15 years of service. He's 55 years old. Well, Severance Calculator tells us correctly that he's owed 14 to 16 months of severance. So not only does this person's father, who's going to be the one terminating employment, have to pay severance, he'd have to pay him 14 to 16 months pay. That's why it's so important for employers too, by the way, to use the Severance Pay Calculator. You see it on the screen right now. That's how it's done. That's how easy it is. You can find that for yourself as well, severancepaycalculator.com.
Again, employmenttv.ca if you want to find out where we do our radio shows all over Ontario for the past, well over half a decade. Do a ton of phone calls on the show. We like to play them back here, get some feedback from you, Lior, so we'll get to a call.
I worked for a Canadian company that got purchased by a European company, and now the European company has now been purchased by a company from Asia. When we were purchased by the European company, we had to sign over into the new company. Will we have to do that with the Asian company buying the European company now? If I don't sign into the new company, does the old company have to package me out?
Excellent question. Very good question, and happens often when a business is sold. So a smart company, I'm going to talk about it from the employer standpoint first of all. A smart company that's buying a business, yes, is going to want the employees that it's taking over to sign employment agreements because the employer can limit its future liability. For example, the new employer can have the employee sign a contract that says, if we do let you go, we'll only give you your minimum severance, we're not going to give you your full one. Now, for the employee, obviously that's very bad. So if you're an employee and the business is sold and you're going to start working with a new company, you'd rather not sign any employment agreement. You'd rather work, frankly, on a handshake. And if the new company is going to take you on a handshake, take it and run. Continue working.
Less is more.
Less is more. Yep. Because they inherit your service. They can avoid inheriting the service if, in fact, the employment agreement says that. If the employment agreement is silent or if you don't have one, that's good. They inherit your service. Now, if you refuse to sign an employment agreement with a new company because it's a bad employment agreement, because it restricts you and takes away your rights, then yeah, the old company is going to have to pay you your full severance. So what I would say is this, rather than talk hypotheticals, if you're asked to sign an employment agreement, you don't know if it's good or bad, if you should sign or not, let me see it. Right. Let me read it. Let me tell you what it means. Let me tell you if you should sign it or you shouldn't sign it. Because anytime you're asked to sign an employment agreement, potentially that is a very bad thing. I know that sounds counterintuitive, but it's a very bad thing, and you could be walking away from tens of thousands of dollars and creating other problems for yourself. So be very careful. Let me see it first.
Well, I mean, you can imagine an employee who's 50, 55 years old. They've got 25 years in the company, and it's like, okay, I'll sign that. And now they're restricted to their ESA minimums. That'd be a disaster.
It is a disaster, and they may not even realize that that's what's happening. Right. But guess when they'll find out? Yep. When they lose their job 5 years later, and they realize, holy cow, that document that I signed back then just ended up costing me $100,000. Yeah. Happens all the time, so don't let it happen to you.
Still to come, no, you are not an independent contractor. That's on the way after a short break. 1-855-821-5900 and help at employmentlawyer.ca as well. More Employment Hour 30 is coming up.
Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact. In most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. Severancepaycalculator.com. Accurate, anonymous, and free. Severancepaycalculator.com. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact. Over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first.
And welcome back to Employment Hour in 30. We got lots to get through here before we wrap it up for another day. Our live Employment Hour radio show happens. You go to employmenttv.ca to find a station where you can tune into that broadcast. You can call us on the radio show, or you can hear the calls that we take on the radio show. So we're going to get to another one.
Are any severance packages allowed to have waivers or deadlines attached to them? Got to have something signed by tomorrow.
How long have you worked there, Susan?
36 years.
What are they offering? How many months compensation?
A year.
Ooh. Yeah. So this is a question about deadlines. And let me tell you, John, every severance offer, everyone has a deadline.
Sure, Friday at 5.
Friday at 5, Monday at 8, whatever it is. Usually it's Friday at 5. And what happens when you see that deadline? You get very nervous.
Panic.
You panic, exactly. Oh my God, I have to accept it or else. Well, it's exactly the reaction that it's trying to get. It's trying to get that panicked reaction, that pressure, so that you accept it and sign it, and then that's it, you're done. So let's be very clear. That severance deadline doesn't really mean anything. Your legal rights do not expire Friday at 5, Tuesday at 8, or any other time. In fact, you have 2 years before those rights expire. 2 years. So because of that, don't worry about that deadline, okay? What you need to worry about is making sure that what you've been offered is adequate, that what you've been offered is proper. Because once you sign, pressure or not, you can't go back. People have told me many times, I signed it because I felt under pressure. I signed it because I was worried that I'm not going to get anything, and I felt under duress. Can I get out of it? No, you cannot. That's the problem. So, again, this person after 36 was offered a year's pay. That's silly. That's half of what they're owed. So let's plug that for fun into the severancepaycalculator.com website. So 36 years old, in their 50s, in a sales role I picked as an example. Well, this person was offered 12 months, and the severance calculator correctly assesses that she's owed up to 24 months pay. Yeah. No. So can you imagine being owed an additional month's pay, and then you're being worried that you have to accept half of what you're owed by the deadline, or then you're not even going to get that. So don't worry about that deadline. That deadline is meaningless. Now that you've seen this show, now you know that when you're staring at that package, you need to get advice. You need to go to severancepaycalculator.com, and I'm giving you my blessing, my permission to ignore that deadline.
I think what a lot of people fear is not only the deadline, that if they don't get in by the deadline, or if they do go back, the deal's going to get worse. They're going to offer me less, like it's a poker game. It's not the way it goes.
The law decides what you get, right? So if the law says you should have 24 months pay, it's not going to get worse because that's what you're legally owed. So it's the example I like to use is, John, if I owed you $100 and I said, John, I'm only going to pay you $20, but for me to pay you $20, you have to sign this document. You'd say, well, thanks, but no thanks, Lior, because you owe me $100. Right. Well, it's the same thing with severance. If the company owes you 24 months pay and they said they're only going to pay you 12 months pay, the answer should be thanks, but no thanks. Right. I'll take my 24 months.
Another resource for you as we get down to the last couple minutes here is terminationquestions.com. You can ask your questions. Lior and his crew will answer them. You can do it online, terminationquestions.com. Example, I've worked for a company for 4 years in a sales position, selling windows and doors. I was just let go. They considered me to be an independent contractor. There you go. I worked exclusively for them full-time, but did not have an office and paid my own expenses. Am I entitled to severance?
So the old independent contractor situation, and we've been talking about this recently on our radio shows as well, but it's important to understand, if you're working for a company regular hours for a period of time, I don't care what they call you, you are an employee. So this person is likely an employee. Not because I say so, because that's what the law says. The law doesn't really care what he thinks he is or what the company thinks that he is. Again, if you have a regular job, if you work for the company, you take directions from the company, you're doing what they tell you to do, you're an employee of that company. As simple as that. Doesn't matter who pays your taxes. Doesn't matter if you've incorporated. None of that actually matters. So if he's in fact an employee, is he owed severance? Well, of course he's owed severance.
Same severance.
Same severance as any other employee. Doesn't matter what he thought he was for the last 4 years. Now, depending on his position after 4 years and depending on his age, it could easily be 6 months pay. It could easily be 8 months pay. So he's absolutely owed severance, John, and I would urge him to call me so we can talk about that specifically. But for our viewers right now, remember, an independent contractor doesn't get severance if in fact he or she is an independent contractor.
Like a plumber.
Like a plumber.
Right.
But are you a plumber? Are you an electrician? Are you someone that's in business for yourself? If so, then yes, you don't get severance. Otherwise, you do get severance because the law considers you to be an employee.
Well, I think the key words in this, as we wrap it up, is worked exclusively for them full-time.
That's all you need to know. If you work exclusively for someone full-time, because the plumber doesn't work exclusively full-time in your house, so he's an independent contractor. This person is an employee. Many of our viewers are employees without even realizing it, so you have rights.
Again, that place is terminationquestions.com. You can go there and other contact. There's all kinds. There's 1-855-821-5900. There is help at employmentlawyer.ca. And don't forget, always, first place you go is
severancepaycalculator.com.
That's the place you want to go to find out exactly what severance you are owed. Till next time, Employment Hour in 30.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.